Joining us live now is the former Federal Court of Australia Judge Michael Barker. Michael, good to see you. Thanks for your time this morning. So what are your initial thoughts on the bill so far?
Well, Pete, haven't seen it yet. Looking forward to seeing it in about half an hour or so with a bit of luck. But we'll be looking to see just how broad the jurisdiction is, just how strong the investigative powers are, and a big question, how the public hearing powers of the Commission will be.
OK, well, on that point, because there has been some pushback already on it only being public under, quote, exceptional circumstances, critics claim that that completely waters down or just waters down transparency. Would you share those views as well?
Yes, I do, Pete. In most jurisdictions in Australia, commissions can hold public hearings where they decide it's in the public interest to do so. The ICAC in Victoria has the exceptional circumstance qualification. And if you think about it for just 2 seconds, if you have to decide as a commission whether something's in the public hearing, but also ask yourself, are there exceptional circumstances to justify the public hearing, it's plainly intended as a brake on the public hearing power.
OK, I had Stephen Jones on the program last hour and asked him about this. He argues, or Labor argues, that there will be an avalanche of cases in the first year, hundreds of them. So is it unreasonable to expect that all of them should be made public?
This is legislation, Pete. It lasts forever. They don't suddenly have the power in 12 months, unless they put it into the Act, to scrap the exceptional circumstances qualification. What you do is allow it to conduct public hearings in the public interest, and you allow the Commission to operate to control its own workflow. We know already from the way ICAC in New South Wales works that over the last 7 years up to 2020, they had over 22,000 complaints issues coming into them, but they didn't hold anything like that amount of hearings. Now, it's going to be a lot of work for a federal anti-corruption commission, but you let it operate. You see how it goes.
An independent commissioner, so not government, be free of government, decides what should be in the public domain and what shouldn't when it comes to exceptional circumstances. Should that provide the public some comfort?
Well, there's a question of what is model anti-corruption legislation and what's, in a sense, run-of-the-mill or other sorts of anti-corruption legislation. In my view, the model federal body should leave it to the commissioners to decide what in the public interest needs to go to a public hearing. The public get full confidence from that system. Where you only have, as in the case of Victoria, about 8 public hearings in that same 7-year period that I mentioned, the public will be much more sceptical. They won't be sure what's happening behind closed doors. You don't have the same accountability, you don't have the same transparency, and I don't think the public will be as full of confidence as they could be through another sort of system.
Some, and I'll probably finish it up here, Michael, but the coalition, it looks as though they may well be on board about this. Some have said that the fact that this has been seen to have been watered down may have been to try and get the coalition on side. Some members of the coalition, and as you probably are aware, had been concerned that it in some cases would become show trials. Even Scott Morrison in the past had accused the New South Wales ICAC of being a kangaroo court. Do you share any of those concerns? Absolutely, none of them.
It seems that some proceedings that have gone through the New South Wales ICAC are brought to be used as some sort of example to water down the federal body. You have to know that when you appoint commissioners who have gone through, we would hope, a joint parliamentary process of their appointment, that they're going to be people who act sensibly. The idea that this is some show trial court, a kangaroo court, is arrant nonsense, to be honest about it. And there are mechanisms for ensuring that nothing like that happens in a federal body.
And do you have any fears that this could be used as a form of get square against the former government?
No, I don't, because the people who run an independent integrity commission are people of high standing. They're there because they're concerned about good government for all Australians, to avoid partial government, people preferring private over public interests, political over public interests, whoever's in government. That's the whole point of hanging an integrity commission like this.